And could I please ask the witnesses to introduce themselves for the record, starting with Mr. Sharp, perhaps, as you're in the middle.
Tim Sharp. I'm the Senior Employment Rights Officer at the Trade Union Congress. It has 48 affiliated trade unions representing 5.5 million members.
Thank you very much.
Hello, thank you for having us here today. I'm an employment law solicitor. My name is Shantha David, and I'm the head of legal services at UNISON, the public sector trade union. We have 1.3 million members, of which 75% are women. And having listened to some of the evidence, there's a lot of discussion around process, and I think I'd quite like, on behalf of the union, to talk a little bit about the effect of particularly employment laws on these this bill will have on workers.
Some of the questions will draw that out from you, perhaps even some of the early questions. Justin Mathers.
Thank you, Secretary. I think indeed that seems a nice point to actually ask you if you could just set out what your understanding of which employment laws will be covered by this bill, and indeed if you could explain a little bit about what you might think some of the effects will be on certain groups of people. But
If I could start. So the bill in the abstract looks at removing EU-derived laws, as we know, but what we don't understand is if these provisions are sunsetted, it'll strip away some very basic employment rights, and I thought I'd set some of those out, and thank you for the question. So, for example, the UK allows for, through the EU-derived provision, allows for 20 days of statutory annual leave. That will no longer survive if this provision is sunsetted. There is also protection for 8 additional bank holidays, which is derived from the UK, but it is contained in the working time regulations. So it is unclear whether those provisions would go along with the 20 days of statutory leave, leaving UK citizens with no provision and no statutory annual leave entitlement. Other typical basic employment rights are things such as the TUC regulations, which I'm sure you will know about, and TUC protections. And what this does is it preserves an employee's employment where their employment is outsourced or brought back in-house, or where an employer's business is brought out by another. And these employees are protected from dismissal, and their terms and conditions are also protected from being varied because of the transfer. If TUC legislation goes, these sorts of employees could be sacked with no legal recourse. So it is unclear what would happen to them. Family-friendly provisions are contained in a variety of different legislations. So they are derived from the EU as well as through acts of Parliament. It is a tapestry of rights. Basic rights to maternity, paternity leave fall under the Employment Rights Act 96, but the specifics in terms of the length of leave or who is eligible for that leave and payment of the leave comes through EU provisions. And given the lack of information that we have, it's unclear what will survive and what will face the chop. Then there are other protections such as the part-time worker regulations and the fixed-term regulations, and these allow for parity of treatment for those types of workers. These provisions will disappear overnight. There are other provisions such as the Equal Pay Act. There are certain facets of it which are derived from Europe. So where there is a single source of payment for people's terms and conditions, an employee can compare themselves with employees in a different establishment. Again, there are cases in the tribunals at the moment and the courts dealing with this particular point. But removing this principle of direct effect will mean that these women in particular can no longer rely on the principle of equal pay for work of equal value. So these are just some of the rights. I'm sorry that there are many more, but we will provide some written evidence if that assists.
Point very strongly made. Justin Mathers.
I just want to come back to one of the points you mentioned, which is very interesting because it sort of contradicts a little bit what some of the witnesses have said earlier on, which is that one of the reasons why we don't need to worry too much about the parliamentary procedure for removing these rights is because we didn't have a proper parliamentary procedure in the first place. It was imposed on us by the EU. But you've given a very good example there of the 8 days holiday pay, which was actually a decision of the UK government. It wasn't actually imposed by the EU. So are there other examples of UK government decisions or enhancements to the EU regulations that will be lost as a result of this bill?
Yes, the TUC provisions provide for certain types of service provision changes and protections for particularly outsourcing and insourcing. These are UK-derived provisions that survived and that were potentially updated in the 2014 regulations, the TUC regulations. At that time, it was interesting. The consultation responses were that there was a certain level of certainty in the provisions, and to keep making changes was unsettling for both businesses. And it was businesses that came out most loudly saying that we all know where we stand at the moment, and let's leave this piece of legislation alone. To remove it altogether will create a great deal of uncertainty and take us back to the 70s and 80s when we didn't quite know what was going on. And the effect of this, of course, will be to block up the courts and tribunals who are already under-resourced, and also there are several delays. We know of the delays, we know of the cases and the backlogs in the court system. So to try and rectify and understand how the laws will work if TUC is removed is very hard to understand.
One more, thank you. And on that point, Mr. Sharp, obviously, as the overall umbrella body for trade unions, you will have discussions with everyone within the trade union movement, but also employers. What kind of conversations are taking place about what the legal landscape is going to look like after 2023?
I think, so following on from what Shantha said, what's clear to us is the rights that we're talking about, not some sort of additional nice to haves. They're really crucial rights, and they're particularly crucial for often low-paid and vulnerable workers. So, particular protections for part-time workers, for agency workers, for security guards and cleaners who are being transferred from one company to another company. And at best, the uncertainty means there's going to be more things that are going to be fought out in the courts. And if you're a low-paid worker, you're holding together multiple jobs, going through that process is both expensive and more than you can probably cope with. At worst, those rights go completely. So we're really worried about the impact of particularly on vulnerable workers. We think it's when you talk to business groups, it appears to be bad news for good bosses who want to do the right thing and follow what the law says. Great news for bad bosses who don't care either way and will have more freedom to kind of do what they like. So we're really worried about the impact of the legislation as it stands.
Thank you very much. A good time to turn to the Minister.
Thank you, Chairman. Ms David, did you mention bank holidays, 8 bank holidays? Yes. So we're going to lose our bank holidays. Are we going to lose the one that we're going to get for the coronation of the King?
I wouldn't know. That's down to
but
the
you're speculating
that
we are, and I'm anxious about this constant speculation and the fear that it's creating.
What?
There are people on this side, and actually on the other side as well, have done a huge amount of work to make sure that women and vulnerable people are protected at work. So I've really struggled with your evidence today, and referencing us falling back to the 1970s and the 1980s. The UK has been actually leading in a number of these aspects. We're the first to introduce 2 weeks paid paternity leave in 2003. The EU's only just legislated for this. We've got the highest minimum wage. We compare us to France, Germany and Japan. We're also leading on paid bereavement as well. We have far more maternity leave. We have over a year. The EU just has 14 weeks. And April 2019, we quadrupled the maximum fine for aggravated breaches of workers' rights. So the assumption that somehow we're going to fall into the 1970s or creating this atmosphere of insecurity, I just do not think is healthy. So my question, just to get to the point, I'm so sorry. The government has stated many times over the past few years that we will not reduce rights and protections as we leave the EU. And the bill contains powers which enable government to preserve and codify the REUL in a way that will incorporate it fully into UK law. What basis is there to be fearful of these rights diminishing? I don't want to hear about speculation. We haven't got enough time. I want to understand what basis there is.
I don't think this is speculation because, unfortunately, the tableau doesn't provide a full list of legislation that is due to go. Without knowing what that is, it is impossible to know what will stay and what will go. And I think it's imperative that the government produces a list. The tableau is the most incomprehensible piece of equipment. You have to put in random words to try and identify whether or not certain pieces of legislation will remain or whether they will go. The working time regulations contain the provision for the 8 bank holidays. Whether or not they stay or go will be down to the government, of course. But at the moment, we don't know. And I think that's the biggest problem. It's the lack of clarity that is causing us the biggest headache. And also, we're talking about 2,400, 3,800, whatever the number is, pieces of legislation that are due to be sunsetted within a year. And if I understand that they will simply go away at the end of next year unless something positive is done to replace them. So if that is the case, yes, we will lose our right to the 20 days of minimum annual leave entitlement. Yes, we will lose women in particular who tend to be part-time workers won't have the protections against dismissal and against parity of treatment. And yes, fixed-term workers who also tend to be female will not have their protections. And those people, women who particularly want to go back to the workplace and have the same employment and have that protection, will not have that protection. So you might think it's conjecture, but without knowing anything else, what else is there? We need to have a comprehensive list of the legislation that is due to be affected. And once we know that, I think perhaps then we can be consulted as trade unions, as individuals, as members of the public, so that we can actually have our say on what we want to keep. I don't think the government intends to simply remove all legislation that assists workers and employees. I can't imagine that must be what the government wishes to do. So it would be helpful to have that information in front of us so we can actually respond.
That's all. Thank you. Stella Creasy.
Thank you, Chair. I thought the Minister just rather helpfully set out a whole range of employment protections that are rooted in retained EU law when it comes to women's rights, and therefore removing the foundation of those laws that have then been applied in UK law creates the legal uncertainty that you were alluding to. Obviously, the answer on this is therefore a commitment, clarity, and a confirmation to all those who depend on these laws that, as the government says, they are going to be retained. Well, exactly which ones are going to be retained? Because otherwise, what is the point of this legislation if we're just going to delete everything and start again? Have you been given, as organisations who work on employment rights, any confirmation, any commitment about these specific pieces of legislation at all?
No, we haven't had those conversations. We're still in the dark, and we are really concerned about the array of rights that's been set out so far today. But even things like laws of health and safety laws as well, and things like protection for pregnant workers. There's lots and lots of protections. So far, no, we don't know. We're sort of seems like we're taking a shortcut, but to an unknown destination.
So just so we are clear then, the reason why bank holiday entitlement exists in UK law is because EU legislation required us to be able to do so, and then we have written proposals for those bank holidays into law on the basis of EU legislation. If we then remove that basis, could an employer challenge, without that law being retained, the right of an employee in the next year to take a bank holiday?
Just to clarify, the 20 days are derived from Europe. The additional 8 days were because I think historically those 8 days were incorporated into the 20 days. So to ensure that people had the additional 8 days of bank holiday, they were allowed for under UK law. But it's contained within the same piece of legislation, which is where the confusion might arise.
So just in terms of my specific question then, it sounds like we'd be going down to 12 days, for example. Could an employer challenge the right of an employee to take a bank holiday if the government doesn't rewrite this piece of legislation?
Actually. So we won't have the 20 days at all. We'll have the 8 days bank holiday only if they're put somewhere, they're taken out of the current regulations and presumably and put somewhere else. Because if the regulations go all together, then with it will go Regulation 13A, which talks about the bank holidays, if that helps.
Thank you. Marcus Fish.
Thank you, Mr. Chairman. I'm quite sure that the government and its ministers will be very keen to make sure that people's rights are preserved that they've been enjoying thus far. I can't personally imagine a scenario in which they wouldn't be very careful about those things. And I just wanted to also point out again that under Section 13, should anything inadvertently go that wasn't meant to go, or had effects that were really bad, have you seen that in Section 13 there is a power that could be used by a future government to effectively to reproduce anything which was retained EU law within the EU Withdrawal Act? So that's Section 8 of, or Clause 8 of Section 13, or am I saying Section 8 of Clause 13? I never know which way around to say it. But there is that in there, but I just wanted to give you my strong belief that that's not where the government would go. I can't speak for them, because I'm not a member of the government, but I would be amazed if there was anything different.
It would be helpful, though, if that were in writing, because as a lawyer, I'm very grateful for your words, but it would be helpful to actually have a full list of what is included. And if that piece of legislation, say, is sunsetted and is introduced at a later date, there will be workers who don't have access to those laws, and that is a breach of access to justice as well.
That would be a strong incentive for the government to get it right, I would posit.
Indeed, but the timing is an issue, because there's only just over a year to identify the pieces of legislation, and as we mentioned, they are a tapestry of rights. So we don't know where one right begins and another ends. And I would recommend the Employment Lawyers Association paper, which sets this out very clearly.
Thank you. David Jones.
I imagine that you both have regular meetings with ministers and senior government officials. Is that right?
I'm a lawyer, so I don't necessarily.
I don't think that necessarily precludes you. But what about
I'm
you?
a practicing lawyer.
What about you, Mr. Sharp?
We meet these officials, for example, on a reasonably regular basis.
Yes. So presumably you've raised your concerns about this issue of protection of workers' rights and the potential impact of the proposals in this bill.
We've raised our concerns about protection of workers' rights on a number of occasions when they've been these sort of speculation has been around in the past and received lovely assurances. I don't think we've met Bayes ministers since. There's been quite a few in the last recent weeks. I don't sure we've met them in recent weeks on this, and we certainly haven't. We haven't had those the confirmation about all the workers' rights. So we know them being retained is certainly something we have not been told.
Have you actually requested comfort from those senior officials on this issue of workers' rights? Have you asked for assurances?
I don't think anyone's been able to tell us anything about what decisions have been made.
Have you asked for assurances?
But I'm unclear how that would.
Well, you clearly are concerned that there may be a wholesale scrapping of workers' rights as a consequence of this bill. Have you asked for any reassurance from those officials to whom you've spoken? Sorry, I thought you hadn't met any officials.
No, but I'm allowed to have an opinion, I think, because I do meet officials from time to time.
Could Mr. Sharp answer this, because he's the person who's at the meeting?
So we've met Bayes officials as the TUC.
Yes.
Have we asked for assurances? We've asked for information on what is planned on workers' rights, and we haven't been given any information on what has been intended.
It seems to me that you haven't asked for any assurance, and that in giving this evidence today, you're raising hairs that, frankly, are completely illusory. And you know full well, don't you, that there is no way that the government would scrap these rights that you're concerned about.
It'd be lovely to think the government's going to retain the rights as they are. I mean, there's even this benign scenario, which would be great if that happens. We're still going to have great chaos, because we're going to have, let's say all the regulations are restated. We've still got all the interpretive principles. We've got all the case law falling away. It's taken, it's for years of worth of litigation to decide whether someone's what entitlement sick workers have to carry over sick leave, for example. We don't know what that position might be after this bill is passed. So if you're a worker or you're a rep in a workplace, you don't want to be going to tribunal and to court to settle all these matters again, which is effectively what this bill does. You want to be able to have a conversation.
A simple conversation might assist, and you've not had it.
I think you've pressed them far enough on this, David. I'd like to hear from Shantha on this, please.
Thank you very much. I was just going to remind Mr Jones perhaps that the equality impact assessment does identify that the laws that might have a detrimental, the removal of them will have a detrimental effect. So I'm not sure that is an assurance, because it isn't. Beyond that, I don't know what help we have. I don't have access to ministers in that way. It takes a while to get an answer in. And much like Mr Sharp was saying, the only way to clarify legislation as we go along and to get certainty in the law, because we won't have it if provisions are sunsetted, is via litigation, and that is something I am able to talk about. And litigation is costly, and pursuing appeals in the senior courts will take a long time because of the delays I mentioned. And given that tribunals and courts, lower courts, will no longer be bound by retained EU law, there is also the question of how long-established principles of precedent would work, whether there would have to be referrals made from tribunals and lower courts to the senior courts, which is what's envisaged in the bill, either to go to the courts of appeal in Scotland, Northern Ireland and England and Wales, or to go directly to the UK Supreme Court. And we are not aware, there is nothing mentioned within the paperwork, which is the only thing we have to work on, that will be resourced in any way. And we already know that it takes at least a year to get to the Supreme Court, UK Supreme Court. There are only 11 justices. I'm unclear as to who will make those decisions around interpretation.
You're obviously a lawyer after my own heart, Miss David, because unless it's there in black and white, it's not worth a penny, is it? So we've heard lots of assurances from various people who accept themselves they're not in a position to speak on behalf of the government. But isn't it the case that unless we do get positive action from ministers and things in black and white, these rights will automatically fall at the end of next year? So the question is, wouldn't it be much simpler then if we put in this bill a clause that said these pieces of legislation, these employment rights, will not be sunsetted?
Yeah. Absolutely. If that is the government's intention, not to get rid of workers' rights and legislation that protects employees, then of course it would be a lot simpler to simply set out what is protected.
I feel an amendment at committee stage coming on. Are there any other questions? Stella Creasy.
Thank you, Chair. And I appreciate this is something people feel very strongly about because they are concerned for their constituents. Can the representatives of the trade unions tell us what it was like when the Beecroft report came out, which talked about some of these issues as well? And so if there is a concern to get not just a promise, but actually a commitment in writing to protect these rights, then such an amendment, do they think that would be a welcome? And would that be enough, given Beecroft shows a direction of travel that this government has previously considered?
That's straight too wide. Because we're considering this bill, but
it is
an answer would be helpful. Yeah, it's relevant.
Rights.
Let's have an answer.
The difficulty we have here is the speed at which this thing is happening. It's not about whether or not you want EU-derived legislation to exist. It's about being able to have a considered view on the employment provisions that exist for workers, and to ensure that we're not mired in litigation. Employers and employees aren't mired in litigation forever and a day. And the costs of this are incredible. And I think that's not completely understood. The costs of litigation are profound. So I think it is important that if there are going to be clear exceptions, and if it is very obvious that certain employment legislation will survive this cull, then perhaps that should be specified, and that would be very helpful.
Marcus Fish has the final question.
Just would you be willing to be part of forces that ministers organise to try to make sure that in the replacement of the EU derived law that the rights which are put in place by ministers and us to replace that, but a part of English common law or UK law, are actually drafted in a way that will give you the comfort that you want, which will then mean that they don't have to be litigated up and down through different courts, because they are clear enough and good enough for what we all want for our constituents, and for your members too.
We would be more than happy to help.
I think absolutely. I think the trade unions would want to engage in such a process. I'm not sure it would stave off the scenarios that we see where the exactly what different rights mean would still end up being litigated. So even in that scenario, great, we'd love to have those conversations. It's really crucial. I think the workers' voice is heard in it, but the bill is still going to cause immense extent of confusion and cost to business and workers, we think.
All right. Well, thank you very much indeed for your evidence, and we do appreciate you coming to see us today. And now we'll move on to our next set of witnesses, and we're slightly changing the language and the tone now. I think we're going to look at the environment, ever important. So we finished 3 minutes early, actually, 4 minutes early. And colleagues, I ought to point out, I think at 4 o'clock, I think we're having a division. Oh, 4:15. Oh, okay. We might get through this group then. We'll get through this group then.